Good evening, everybody, on this beautiful, gorgeous day. So nice to know that spring is actually coming. This evening, we're having Orin Saltzman, a prominent attorney in Maryland, and he's going to be speaking on estates and estate practices. And I'm going to let him introduce himself. I've known him for a long time, and he's known me too. And I'm just going to let him talk to you. Okay, Orin, take it away.
Thank you, Judy. So my name is Orin Saltzman. As Judy said, I am an attorney in Maryland. My practice areas are business, corporate, estate planning, and estate administration. I have a master's degree in taxation from the University of Baltimore, as well as a law degree. I've been doing estate planning for many years. When we're talking about estate planning, what we're really talking about is two different things. The first thing is um, estate planning prior to your death with regard to certain documents, and we'll get into that in a moment. The second aspect is the will, the possibility of revocable trust, and we'll talk about is that as well. What's most important for most of you, because of your unfortunate illnesses, is um, what are you going to do to protect yourself and your family while you're still living? So what we're going to start with is estate planning documents that can be created while you're alive. The first one, and then probably the most important, is a power of attorney. Maryland enacted about 11 years ago, maybe 12, a statute, a power of attorney statute that actually was promulgated through the American Bar Association, that created a unified power of attorney so that financial institutions would be required to use those powers of attorney and to enforce them, so that an agent could act on your behalf. It's generally, we call it the statutory power of attorney. And it basically allows your agent, some people call it your power of attorney, but it's really your agent under the statute, to act for you, whether you're able to act or not. Generally, we have the powers of attorney take effect immediately. So as soon as you sign it, and it continues until your death. At your death, the power of attorney no longer is in existence and it terminates. The power of attorney has a number of subjects in it, but they're all related to financial matters. So we're talking about your bank accounts, your retirement accounts, your financial accounts, your stock accounts, anything related to your financial well-being. Your agent, if you agree to it, your agent is able to basically act for you as if it were you yourself. They can do anything they need. Why this is so important is because there will be times when you will not be able to handle your own financial affairs and you need someone to do it for you. If you don't have a power of attorney, then no one can act for you with regard to these kinds of accounts. And basically what that would mean is that financial institutions like banks, your large houses like Morgan Stanley and Fidelity and so forth won't deal with the person, even if it's your spouse. They still will not deal with you. The power of attorney gives your agent the right to act on your behalf. So Maryland, the statutory forms in Maryland, there's a short form and what's called a limited form, which is actually the longer form. It takes a while to fill out, and it's kind of complicated, but generally your attorney can help you and walk you through it. It's very important to have. The short form is still a financial power of attorney. It is shorter. It's not quite as comprehensive, but it generally works. If you have not executed a new power of attorney within the last 10 or 11 years, that's something that needs to be done quickly, because the power of attorney that you have is probably a power of attorney that was created by a law firm. And banks will tell you that this is not our power of attorney, we won't accept it, and then there's a problem, particularly if you're incapacitated. In order to sign a power of attorney, you must have capacity, not physical capacity necessarily. You must have mental capacity. If there's a question about your mental capacity, I generally like to get a physician's note saying that this person is able to understand what they're doing, and they do want the agent to act for them. Everyone should have a power of attorney. It's very important, particularly as you get older and as you get more infirmed. The second document that people should consider executing while they're still capable of doing so is an advanced healthcare directive. An advanced healthcare directive is also statutory in nature, and it allows also your agent, they also call it your agent, to act for you with regard to your person, with regard to your health. The first part of any advanced directive is a HIPAA authorization. HIPAA is the federal statute which provides that all your medical records and your healthcare providers information, and even speaking with the healthcare provider, is private, so that your spouse cannot even talk with the healthcare provider about your health. And I've had a situation where a healthcare provider refused to speak to a spouse. That's unusual because generally they will talk to a spouse, but it's better to have a healthcare directive. The second part of the healthcare directive will always be the authorization of the agent to act for you. If you are able to in any way communicate and you have capacity to do so, you are still in charge. It's when you no longer have capacity that your agent would take over. And then the third part is the what I call the living will. And we look at three conditions under those circumstances: a terminal condition, a persistent vegetative state, and an end-stage condition. They're all a little different. Basically, a terminal condition and a persistent vegetative state is a situation where your death is imminent and there's very little they can do to prolong your life or to increase the quality of your life. For all intents and purposes, you're brain dead. You're not able to communicate or do anything, and death is very close. The difference between the two is a matter of time. A terminal condition is a shorter period, while a persistent vegetative state is a more prolonged period. The third condition is an end-stage condition. An end-stage condition is a condition where there's nothing they can do to prolong your life or to increase the quality of your life, but your death is not imminent. There may be times, imminent. There may be times when you are aware of what's going on, but usually it's marked by unconsciousness. And in that situation, there may be periods when you're aware of your situation. Most people don't want to be on a respirator, and so in the healthcare directive ensures that you won't be put on a respirator. You will be given, under the healthcare directive, you will be given all the medication you need in order to make you comfortable, but you don't necessarily have to have food or hydration. So depending on your condition and what you say in the advanced directive, you can withhold food and hydration if you want. A similar document to that, but it's different, is called a MOST, a Maryland Medical Orders for Life-Sustaining Treatment. It is provided by your physician, not your attorney, because your physician has to sign it. It's very similar to a advanced healthcare directive, but it's more specific as to whether you want to be a DNR, CPR. It's more specific as to how you exactly want to be treated under the circumstances. If you don't have a MOST, you should get a MOST. Again, it's a Maryland Medical Orders for Life Sustaining Treatment form. Very important. Another document that you may want to consider executing while you're still doing well is a revocable trust. A revocable trust is a trust that's in existence during your lifetime. Basically, it allows your trustee, and you generally are the trustee, to control your assets through the trust. You have to transfer all of your assets into the trust, and then the trustee takes control. The reason why I bring this up is sometimes people think that a power of attorney and a revocable trust do the same things. In reality, that's not really true. If the property that you are concerned with is a part of the trust, then yes, the trustee could then control the asset like a power of attorney. But if the asset is not part of the trustee has no control over it. With a power of attorney, the all your properties, regardless of how it's titled, as long as it's in your name, is controllable by your agent under the power of attorney. So it's something to consider, a revocable trust, but to me, the most important document is the power of attorney. The revocable trust upon death, your death, becomes irrevocable, and then it acts like a will. And we'll get to wills and trusts regarding the transfer of your property and your estate in a couple minutes. I just want to stay on things regarding to your while you're alive first. The other type of not document, but action that you can take is a guardianship. The guardianship is the least favorable type of situation, because basically what that means is that a petition has to be filed with the court, and two physicians have to say you're not capable of taking care of your person or property, guardianship of the person and property. Basically, the court becomes your guardian, and the guardian who is appointed, usually a relative or a friend, sometimes it's an attorney, acts on behalf of the court. The guardian has the right to basically do anything that an agent and a power of attorney has. And that's why it's preferable for you to have a power of attorney rather than having to go to court and get a guardianship. A guardianship can be expensive. It can be uncomfortable. It can be embarrassing for the family because the guardianship is taken up in open court, but sometimes it's necessary. So of all of these items that we were talking about, the two most important that you should consider obtaining if you don't have it already is a power of attorney and advance directive. Then upon while you're still competent and you're able to understand what's going on, you should also have a will. A will only takes effect upon death. Basically, what the will says is who you want to leave all your property to. It's like a revocable trust, except that a will requires that the asset be probate, which means that it has to go through the Register of Wills. And if you're living in Maryland, it'd be the Register of Wills in the county that you live in Maryland. It's not going through probate is not a bad thing for most people. It's fairly simple. The registers are very cooperative. They make things easy. So having a will is okay. And generally, I prefer wills over revocable trusts only because during your lifetime, the assets remain yours, rather than a revocable trust that you're transferring it over to a trust. And if you're not the trustee, you're not in control of your own assets. The will generally will say how you want your funeral to take place, who you want to leave your tangible assets to, who you want to leave the remainder, which is intangible assets, real property, your home, and how you want to go about ensuring that upon your death, your estate is properly administered by a personal representative. You'll name a personal representative in there. And wills can become more complicated by creating a trust within the will. That's called a testamentary trust. It's different than a living trust, which is a revocable trust generally, because the trust in a will only only takes effect upon your death, whereas a revocable trust has to take effect while you're still alive, and then it becomes irrevocable upon your death. So having a will is also an important document to ensure that your assets are properly administered upon your death. What we're looking for when we do a will is two things. One is, do we need to worry about a dependent or someone who has special needs? And the other is whether your estate is large enough that we have to worry about estate taxes. There are two estate tax regimes that we worry about. The first one is the federal estate tax. The exemption for the federal estate tax right now is $13,900,000 per person. So that would mean if you're married, you have $13,900,000 of an exemption, and your wife does as well, or your husband. And that exemption remains in effect. The $13 million remains in effect until the end of 2025, when it may sunset under the current law. I'm pretty sure that under the new legislation that's intending to be passed, that provision is going to remain, and that the $13 million exemption's going to continue. The second estate tax regime is the Maryland estate tax. Maryland does have an estate tax. The current exemption for the Maryland estate tax is $5 million per person. $5 million for you and $5 million for your spouse. That right now is under attack in the Maryland legislature, and there's a possibility that exemption may go down to $2 million per person, which would cover a lot of middle-class people. I'm kind of hoping that that doesn't take place. I think $5 million is probably fair per person. $2 million per person is a little low. If we have to worry about the estate tax, there are ways to handle preparation of your estate, of your will or revocable trust, so that no estate tax would be paid. Generally, what we do is we create, if you're married, we create a trust where a portion of the trust can be designated to fall outside of your estate and fall into the trust, so that it's not, upon the death of your spouse, it's not considered a part of his or her estate and not included in the estate tax. There is an absolute exemption for husbands and wives. So you can leave your spouse your entire estate without there being an estate tax. However, upon the second to die, that's when you have to worry about what the estate tax exemption would be. So it's important to set up the proper documentation prior to either spouse passing away, so that you can use the exemptions properly. As I discussed earlier, the will also provide that if there is a trust, that there is a trustee contained in the will, and that the property is properly administered through the estate. Usually, the estate takes 6 to 9 months in order to administer, and it really is a way to transfer assets into to your heirs. One of the important parts of estate planning these days is what's called a step-up in basis, which means that upon the death of a person who owns property, the original basis, what you originally purchased an asset for, is stepped up to the value as of date of death. So one of the things that will occur is that all of your property will have to be appraised in order to know what the value is out of date of death in order to obtain the stepped up basis, so that when a asset is sold, there won't be a lot of capital gains. So that's an important aspect of estate planning as well. That's basically what I was going to say. I don't know if you want to go ahead and ask some questions.
Yeah, there is someone who's, yeah, I've got plenty of questions here, but this one, which is not letting me open it. Hey, Michael. All right, I'll just ask another one.
Yep. Yep.
I can't get into the chat to read the question.
Oh, okay. It's in the Q&A, and the question is, can you discuss the difference between general wills and pour-over will? Doesn't pour-over will avoid probate and taxes?
No. A pour over will is a pour over will is used as part of a estate planning for a revocable trust. So you have a revocable trust in place that has most of your assets contained in the trust. A pour over will is used and created in order to ensure that any assets which were not transferred into the trust are ultimately transferred into this trust, so that they will run through the same process as all the remaining assets that are in the trust. So it's just a will, but it provides that all of my assets will be transferred to my revocable trust dated whatever date your revocable trust is dated. So it's the same thing as a general will. A general will, just there's no revocable trust. It just says I leave all my assets to my spouse or to my children or whomever you're leaving it to, without a trust that's already in place.
Okay, someone else asked, what is the best way to prepare for possible long-term care?
Well, I think having a power of attorney is important. And I think an advanced healthcare directive is important. I think what you may be asking is, what happens if your assets are reduced to the point where you have to get Medicaid? And if that's the case, with regard to Medicaid, what you want to do is you want to ensure that if you are married, that your spouse is considered the community spouse, so that they're entitled to keep, if not half, more of your estate. Generally, I'm an estate planner. I'm not an elder care lawyer, but generally, what elder care lawyers like to do is they will create what's called an irrevocable trust. During your lifetime, it's a living trust, but it's irrevocable, which means that just like a revocable trust after your death, it's not revocable. And that irrevocable trust is then outside of your estate for purposes of a determination through the proper authorities to determine whether you're entitled to Medicaid. I'm not sure what's going on with Medicaid under the current regime. I don't know whether it's going to continue. I'm not sure, but the amount of assets that you're allowed to keep in order to be eligible for Medicaid is very small, and so that's why people put their assets into irrevocable trusts. It has to be in that trust for a period of 5 years. There's a look back period of 5 years. If that 5-year period has not been reached, then the authorities determining whether you're entitled to Medicaid will not grant you the ability to receive Medicaid until the look back period has been completed, the 5-year period. So they are going to make you what's called spend down, which is spend down your assets in order to reach that point where either because it's hit the 5-year period or because you've hit the asset limit, you no longer you become eligible for Medicaid. So be careful. Medicaid and Medicare are different things. Medicare is the ability to have insurance through the federal government when you're 65. It applies to everyone. Everyone can get it. You don't need to spend down. You don't need to, there's no asset limit on Medicare. Medicaid is different.
Okay, here's another question. I would like to develop a checklist for my beneficiaries to easily follow after my death. What do I need to do to make their life easier in administering our estate? Can you recommend a source for such a to-do list?
Well, as part of the will, I'm not sure exactly what you mean. I'll tell you what I do, but let me just, as part of the will, I allow the person who has signed the will to have a memorandum, which basically sets forth where you want all of your tangible personal property to go. It's not the same thing as having it contained within the will. I'm very particular about what goes into the will. I don't mind family heirlooms that are very valuable, and I'm not talking about monetarily valuable, but valuable to the family, valuable to you. To you. I don't mind that in the will, but things like furniture and maybe some pieces of jewelry and so forth, a memorandum works. What I do in terms of a checklist is I provide everyone with a last letter of instructions, which gives the person the ability to sit down and look at where you want to have your funeral, who you want to perform the funeral, where you want to be buried, what cemetery, all the passwords for your social media. If you do use social media, it allows you to also do a checklist of things that you want to make sure that people do, including if you have things in the safe deposit box, how to get into the safe deposit box. I would not put valuable papers in a safe deposit box if no one can get into it, because then it has to be drilled. So if you have a child or a friend or a relative who's younger, whose signature appears on the safe deposit box, that's fine. But if you don't put your valuable papers in there, because it's going to then have to be drilled, and that takes time and money, and it doesn't make sense. You put things in important places. A lot of people like to register their wills with the Register of Wills in the county where they reside. I generally don't do that for my clients. I keep it in a safe in my own office, so that both I and my associate would be able to reach the document if it's needed.
Okay, what do I need to do in order to get my financial house in order? Who do I need to see?
Not an attorney. We're notorious for not being good finance. No, I'm kidding. Um, it depends on it depends on what your worth is and what we're talking about. If we're talking about stocks and bonds and financial accounts, then I would seek out the advice of a financial planner. There are lots of them out there. I'm sure Judy has some referrals who she could give you to, and if she doesn't, then she can ask me, and I can give a referral to you. That person will then help you sit down and come up with an estate plan, which would then translate ultimately to a lawyer. If you're talking about debts, then you may want to go see a debtor's attorney, a bankruptcy attorney, to allow you to discuss how to go about to reduce your outstanding debts. nothing's embarrassing about having to file for bankruptcy if that's the proper way to go. People do it when they have medical bills that they can't pay, when they're in a situation where they have no alternatives because of the lack of income or the lack of wealth. And so there's nothing that you should be embarrassed about. It's something that a lot of people have gone through, and it's can be a very helpful process.
Is palliative care the same as hospice?
Yes and no. You're in palliative care when you're in hospice, but you're not necessarily in hospice when you're in palliative care. It's a broader term. Basically, it means that you're in a situation where your death may not be imminent, but you need help. You need the ability to remain pain-free through taking of pain drugs if necessary. Hospice is a little more involved in terms of there's generally a hospice person with you most of the day who will help you until your unfortunate passing. So it's a little different. It's a broader term, palliative.
Um, what papers do I really need to keep and for how long? And then another question, but it goes with this, I guess, is what can I shred?
That's an interesting question. So uh, it depends on what the papers are. Um, the IRS generally recommends that you keep tax returns for 6 years at least. So anything that's older than 6 years, if you filed the tax returns, if you haven't filed the tax returns, then you should file them, but you need to keep them. So at least for 6 years in terms of tax returns. Um, Bank account statements, generally the banks are able to pull up bank account statements online. So I'm not sure that you necessarily have to keep them at all. I generally like to keep bank account statements for up to 3 years. And the reason why I keep things up to 3 years is because generally a statute of limitations in Maryland with regard to causes of action are for 3 years. So anything that relates to a document which I may need in order to protect myself, to defend myself, I want to keep for that 3-year period at least.
You mentioned that the financial power of attorney is terminated upon death. What document is needed to take action after death then?
It will.
The will.
It will. The power of attorney is in existence during lifetime, and then the will takes the place, and the will has a personal representative who is required to marshal all your assets, ensure that your estate is administered.
Can you shed any light on how to protect your investment assets if you ever need a Medicare bed in an assisted living facility?
Okay, once again, Medicare is different than Medicaid. Okay, you are entitled to Medicare regardless of your financial wherewithal. There are some Medicare payments which will be made for skilled care. I think it's up to 115 days of skilled care for Medicare. If you need a Medicaid bed, which is different, I'm sorry, Judy. What was the question again?
Oh my God, wait a minute. Can you shed any light on how to protect your investment assets if you ever need a Medicare bed in an assisted living facility?
Okay. Once again, I'm not an elder care lawyer, but generally, what elder care lawyers try to do in order to protect it, taking into account the 5-year look back period, is put the assets into an irrevocable trust so that it's not part of your estate for purposes of for making a determination as to whether you're entitled to Medicaid.
Okay. My husband and I live on Social Security and our investments. I'm worried that if he ever needs assisted living or care and I need a separate home, we can't afford both, and that would eat up our investments.
So as part of the, again, I'm not an elder care lawyer. I'm sorry to keep repeating that, but as part of the determination is whether, as to whether a person's entitled Medicaid, I'm sorry, they will do a determination, they being the Maryland Department of Aging will do a determination as to what assets need to be spent down in order to entitle the person to Medicaid. Generally, what they'll allow is the community spouse, the spouse that's still in the community, to stay in the house and to retain at least half of the assets. It's not necessarily, you don't have to spend down your entire wealth in order to receive Medicaid.
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 Okay.
Medicare is not financial.
When should I have an advance directive? And I think you might have answered this, but what exactly is an advance directive? And is an advance directive the same thing as a living will?
A living will is part of an advance directive. You should have an advance directive immediately, particularly since it sounds like you are of capacity while you are able to have a advance directive mentally. I'm not talking about physically, because you don't necessarily have to sign the document with your full signature. You could use a mark if necessary. But as soon as you can, you should have an advance directive. What the advance directive is, and I did go over that, but I'll just quickly go over it again, is it gives a HIPAA authorization. It authorizes your agent to act for you with regard to your medical care and obtaining medical records. And the third part is the living will aspect with the three conditions: a terminal condition, persistent vegetative state, and end stage condition. So it's very important to have an advance directive. That's one of the two documents that we were talking about that you should have now, or three documents, including the will.
Is there a difference between a financial power of attorney and a healthcare power of attorney?
Yes, completely different things. A financial power of attorney deals with your finances, and a advance directive, which is a healthcare power of attorney. I don't call it that because it's confusing. It's an advanced healthcare directive. Deals with your person, your health, your treatment with a healthcare provider.
So I would think that along with all this, there probably are difficult conversations that need to be had. And are there people who can help facilitate those kinds of difficult conversations?
Are the conversations with your children? If they're with your, I don't know. Yeah, if they're with your children, and an estate planning attorney can sit down with everyone, though. Usually, while the estate planning is going on, I ask the children to be excused so that you can talk with the person that you're preparing the documents for without concern that they're being unduly influenced by their children or whomever else is with them, their assistant or something like that. So yes, an attorney, an estate planning attorney, is a viable means of sitting down and having discussions with family members, and they can act almost like a mediator if that's necessary.
Aren't there also I guess there's social workers who specialize in elder care issues?
Yeah, yeah, I believe
So
so.
it's
Yeah,
another
I
group.
mean, you can go to an elder care attorney as well, not just an estate planning attorney. An elder care attorney will have knowledge of social workers, and there are also organizations that will help you if you need someone to organize your medical appointments and ensure that you have everything you need. They call them geriatric managers. And it's actually a very good way to ensure that you get everything that you need medically and physically and so forth.
Does anybody have any other? Oh, here's another one. What's this one say? Where- Oh, I'm just gonna choke. Where is your office located? And we would like to make an appointment. He's in Columbia
Well, thank
and
you.
he's
I'm in
great. He's
Columbia.
great.
I'm
He's
in
great.
Columbia. You can look up, it's the law offices of Orin Saltzman. Both myself and my associate, who happens to be my son, who happens to be on the board of maps.
True. Why he isn't speaking tonight.
Why he isn't?
Yeah.
I'm the estate planner. But be that as it may, so we can help you with that.
I think any other questions from anybody? I think that's all I've got.
Debbie did have another question, or Deb,
Oh,
sorry.
go
You
ahead.
mentioned that the financial power of attorney is terminated upon death.
I've read
What?
that one
Oh,
already.
you already read that. Okay, I'm
Yeah,
sorry.
that's okay. You just get right in there because, sometimes it might be necessary. No, but I did read that one. Orin, can you think of anything else you want to tell people?
I
Orin?
think, yeah, I was thinking about it.
Oh, okay. Let's snap
I,
to it.
I think, I think that if you do not have a power of attorney, an advance directive, and a will, that is something that you should get on the phone and just call your attorney tomorrow. You don't necessarily have to use me, but there are plenty of attorneys out there who have it. Just make sure that they're using the statutory form for the power of attorney, and that you're comfortable with the documents. You understand the documents. If you don't understand the documents, ask questions. If they don't want to answer your questions, you're with the wrong person. Find the right person that will explain to you exactly what the documents are and what they mean, and how you go about ensuring that you're protected while you're alive. It's just as important to be protected while you're alive as it is after your death.
Okay, anybody else got anything? Well, Orin Saltzman, thank you very much for doing this evening. I hope everybody found it, really helpful and useful. And please, you're going to get an evaluation form. And if you would like to have us get an elder law attorney do one of these, I'm happy to make that happen. Or any other suggestions for topics for these sessions would be great. So again, Orin, thank you for taking the time to do it. And everybody who signed on, thank you for taking the time to do it. And I hope it was helpful. And I hope tomorrow's as nice a day as today was. Thank you and good night, everybody.
Good night.
Good night. Oh, wait a minute. Is there a question here? Oh, just thanks very much. Very helpful. Well, thank you for saying that. It's nice to hear. Please fill out the evaluations. Okay, thanks, everybody. Good night.